Good evening, everyone. It's Tamara T. Bush. I wanted to make it a point to go live during the month of March to talk about the Fair Credit Reporting Act, because I know that there is a lot of confusion and there are a lot of misconceptions in terms of some of the things that are being done in the industry and the way that we are being treated as consumers by these companies that have a duty to do what they're supposed to do, right? So today, I wanted to go ahead and focus on some definitions that appear within the FCRA, just to sort of begin to provide clarity, some clarity and some education, especially when we try to go it alone or we hire someone to work on our credit. So I think that if we can just get a handle on some of the definitions surrounding the FCRA, we'll definitely be more knowledgeable of what our rights are, and we'll know how to properly assert ourselves when it comes to dealing with companies that are reporting adverse information on our credit reports, and when it comes to the CRAs, the credit reporting agencies that are reporting inaccurate, unverifiable information on our credit report. So good evening to everyone. It's just short of 7 o'clock. If you can see me and you can hear me, please go ahead and place a 1 in the chat. I will definitely love to hear from you. Definitely would love to hear from you. Hold on 1 second. Let me just check to make sure that that I am live. Okay, great. All right, so we are. Okay, so let me go ahead and share my screen. Because there are some things that I definitely want to go over. Okay, hoping you all can see my screen. So this is U.S. Code Title 15, Chapter 41, which is defined as the Fair Credit Reporting Act. So as you can see, there's multiple chapters within this section that basically defines the duties and responsibilities of us as consumers, in addition to the duties and responsibilities of those companies that utilize credit reporting and take advantage of credit reporting in some way, shape, or form. So the first section of this is congressional findings and statement of purpose. Now, let's just sort of break down this section. Now, the one thing that I've learned when reading these laws is that laws read differently than regular English. It's like a law, it's like a language inside of a language, right? So when you're reading a sentence of a law, the best way to have the full understanding of that sentence is to ensure that you have the definition of each word inside of that sentence, right? So congressional findings and statement of purpose. So basically in the chapter, Congress is saying, hey, this is what we found based on our research. This is what we see in the industry. And so because we see certain things happening to consumers, we had to go and construct these laws and put these laws in place to protect those that are unaware of what their rights are, right? Okay, so accuracy and fairness of credit reporting. Congress makes the following findings. The banking system is dependent upon fair and accurate credit reporting, which is true. Because the thing of the matter is that we as consumers are always being solicited to, we're being marketed to. We are the ones that these banks and financial institutions need to take advantage of their products and services that they offer. Without us, there is no bank. So we know that the banks and the lenders need us to utilize their products and services. So the banking system really is dependent upon fair credit and accurate fair and accurate credit reporting, because if we don't have the credit, we can't go and take advantage of the products and services that are being offered by the bank, right? So now, inaccurate credit reports directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence, which is essential to the continued function of the banking system. An elaborate mechanism. An elaborate mechanism. This is an interesting word. What exactly does that mean? What does that mean? An elaborate mechanism. Now, a lot of you define TransUnion, Equifax, and Experian as credit bureaus. The term bureau means federal, and there is nothing federal about Equifax, TransUnion, and Experian. They are regular corporations and LLCs, just like you were to start a corporation or LLC with your Secretary of State. Congress did not appoint TransUnion, Equifax, and Experian to do anything. They took it upon themselves to assume a vital role in assembling and evaluating consumer credit. They've assumed that role. They were not appointed by Congress. They are not backed by Congress. If you all pay attention to different federal websites, you'll know that any federal website is going to have .gov at the end of that particular name. Equifax, TransUnion, and Experian are .com. They are not .gov. They are not backed by Congress. They were not appointed by Congress. They assumed a vital role, right? Congress defines them as an elaborate mechanism for investigating and evaluating the credit worthiness, credit standing, credit capacity, character, and general reputation of consumers. Who is a consumer? A consumer is you. You are the individual. There is a need to ensure that the consumer reporting agencies exercise their grave responsibility with fairness, impartiality, and a respect for consumers' right to privacy. Remember that, right to privacy. You have a right to privacy. You have the right to not want to have your credit information reported. You have the right to not have your private transactions that you conduct, your private business that you conduct with any financial institution, any bank, any company, to not be reported. But these companies, they don't tell you that. You think it's their responsibility to report when you went and apply for a loan, or you went and apply for a house, or you're paying a car note. You think that a lot of us think that it's their responsibility to do that, but nobody told them to do that. They assumed a vital role. They assumed it. Right, so it is the purpose of the subchapter to require that consumer reporting agencies adopt reasonable procedures for meeting the needs of commerce for consumer credit, personnel, insurance, and other information in a manner which is fair and equitable to the consumer with regard to the confidentiality, accuracy, relevancy, and proper utilization of such information in accordance with the requirements of this chapter. Okay, so here's the definitions. We're going to go over a few definitions, right? Okay. The term person means any individual, partnership, corporation, trust, estate, cooperative, association, government, or governmental subdivision or agency. So what does this mean? This means that they define a corporation as a person. Person just doesn't mean individual. A corporation or a trust, basically any entity shown here is also defined as a person. So when you're reading through these laws, knowing that they define person also as an entity, that's going to tell you who assumes what role in a consumer credit transaction. Now, it does say individual, but the one thing that you see that is not there, it does not define a person as a consumer. The term consumer doesn't appear anywhere in this definition. So just keep that in the back of your mind. All right, so the term consumer means an individual, period. Consumer reporting agency. Well, let's go back to consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. So when you think about your credit report, quote unquote, you're thinking, okay, something that's being reported by Equifax, TransUnion, and Experian. But what else does it say? Consumer report means any oral or other communication, okay? Some of you have a criminal record. Isn't that another form of a consumer report? Any information that is compiled about you is considered a consumer report. So companies that are reporting information about you in terms of your criminal record, your credit report, your medical history, any possible report that you can think of that is compiled about you that is going to affect your general reputation and describes personal characteristics is a consumer report. So don't just think about your credit report, it's all reports, right? It's all reports. Personal characteristics or mode of living, which is used or expected to be used or collected in whole or part for the purpose of serving as a factor in establishing consumers' eligibility for. Now let's go back to oral. Why is it a thing for us to only think that these third parties who have no firsthand knowledge of who we are, what we do, any type of private transactions that we have conducted are the only ones that can take and compile a report about us? It does say oral. It says written, oral, or other communication, right? So why is that there? It's telling you that there is more than one type of consumer report. It's not just written, and it's not just provided by the consumer reporting agencies. Okay. Collected in whole or part for the purpose of serving as a factor in establishing the consumer's eligibility. Right. Credit insurance to be used primarily for personal, family, or household purposes. And that's the definition of a consumer reporting agency, right? That's considered a CRA. A CRA is Equifax, TransUnion, and Experian. So we want to begin to address them by their proper name. They are not credit bureaus. They are CRAs. Bureau means federal. And the only bureaus that I know of is the Federal Bureau of Investigation, the FBI, and the Consumer Finance Protection Bureau. Those are the only two bureaus that I know of. So TransUnion, Equifax, and Experian are not credit bureaus. Now, these definitions definitely make a difference, right? Because when we begin to deal with them and go after them for violations of the FCRA, we have to properly define who they are in order to be able to get the remedy that we're looking for, right? We have to define them how the court would define them, or we have to define them how an arbitrator would define them by their proper name as defined by Congress, right? The term credit bureau, somebody just, I'm sure years ago, they just made it up because Congress does not define them that way. So why do we define them that way when Congress defines them as an elaborate mechanism? All right. Okay. So this section right here is basically defining what a consumer report is. What a consumer report is. We call it a credit report, but it's a consumer report as defined, right? The term consumer report. It's a consumer report. We're looking at the proper definition. Okay. So when we scroll down to this section right here, this section right here is basically telling us what a consumer report should include and what it should not include. Okay, except as provided in paragraph 3. The term consumer report does not include information solely as to the transactions or experiences between the consumer and the person making the report. Okay, so who's the consumer? The consumer is an individual. The consumer is you. Who's the person? What did we say? The person means an individual, partnership, corporation, trust, estate, cooperative, association, government, or governmental subdivision or agency or other entity. So if Congress is basically saying here that your consumer report should not include transactions or experiences between you and the company that you're doing business with, then why are these consumer reporting agencies violating your privacy and reporting this information? A transaction experience is pretty much what you think it is. Anytime that you go and apply for a loan, anytime that you apply for a credit card, a house, you apply for a house to rent, anytime that you make a payment on your car, your loan, your house, anytime that you miss a payment on your car or your loan or your house, you get a 30-day late on your credit report. If you have a charge off, a collection, these are all considered transaction experiences. It's a transaction, right? It's a transaction. Exclusions. The term consumer report does not include information solely as to the transaction or experiences between the consumer and the person making the report. Communication of that information among persons. So if you have a Bank of America loan that gets charged off and Bank of America takes and sells that information to a debt collector, and the debt collector comes after you for the difference of the charge off balance, that is considered communication of that information being the transaction or the experience between you, the consumer, and the person, Bank of America, making the report. All right. That's what that means. Unless there's some type of common ownership or corporate control, they should not be reporting that information. I'm not going to read the whole thing. I'm just trying to get you all to see certain points on here. Any authorization or approval of a specific extension of credit directly or indirectly by the issuer of a credit card or similar device. And this is still the exclusion section. So if I get approved for a credit card, why is this being reported on my credit? Why is it being reported? Right? You know, and then it goes into the medical information. So all of these things that are being reported on our credit, it's a violation of privacy because we did not specifically provide explicit written or verbal permission for these companies to share our personal protected information. So medical information is not just about the HIPAA laws. HIPAA, before we even get to the HIPAA laws, I need you to tell me why you violated my privacy and reported this medical debt, because I did not give you explicit written permission or verbal permission to report this information on my credit report. Right? The term investigative report means a consumer report or portion thereof in which information on a consumer's character, general reputation, there's that thing again, your reputation, personal characteristics, or mode of living is obtained through personal interviews with neighbors. Okay, this part right here. Okay, so when you send a dispute letter to the CRA, asking them to validate the item that you're disputing on your credit report, your credit report then begins to be an investigative consumer report. What does it mean? A consumer report or portion thereof in which the information on a consumer's character, general reputation, personal characteristics, or mode of living is obtained through personal interviews. Okay, so when you send in a dispute letter to a CRA and they come back and they state that that item is verified, that happens all the time, right? So typically what they're doing is they are purchasing information from other smaller credit reporting agencies that has been compiled on you for decades, right? 9 times out of 10, unless it's a specific type of dispute, they don't even contact the original creditor to get any information on you. But according to this subchapter E, they're supposed to conduct personal interviews with neighbors, friends, associates of the consumer reported on. So what does that mean? Okay. Hey, Miss Tamra. Someone that you know submitted a dispute of a credit card that they say is not theirs. Do you know a person by the name of, I'm just gonna tell you my husband's name. Do you know a person by the name of Paul Bush? Yeah, I know a person by the name of Paul Bush. Oh, okay, great. So Paul Bush is disputing the credit card that he applied for back in October of 2021. By chance, were you there with him when he applied for that credit card? Do you remember the name of the company that he applied with? Do you remember the amount of credit that he was approved for? Do you remember if he's making his payments on time? That's what a personal interview is, right? I'm actually picking up the phone, calling people, going and knocking on doors, just like the FBI was conducting an investigation about a crime that was committed, or the police was conducting an investigation about a crime that was committed. They actually conduct personal interviews. They cannot rely on the facts, or they cannot rely on information provided by third party that do not have firsthand knowledge of the transaction. So that is the definition of an investigative report. Friends or associates of the consumer reported on, or with others with whom he is acquainted or who may have knowledge concerning any such items of information. However, such information shall not include specific factual information on a consumer's credit record obtained directly from a creditor. Okay, so what are they saying here? They're basically saying that they have to conduct personal interviews in order to validate your debt. What they cannot do is rely on the information that is provided by the creditor that is actually making the report. So when you submit a dispute and it comes back verified, and it comes back really fast, right? Oh, verified. Oh, how did you verify this information? What was your method of verification? What was your method of verification? Because you didn't notify me and give me a list of people that you were going to call and conduct personal interviews with in order to validate this debt. You went to the original creditor and you're basing your findings solely based on the information that you received from the creditor that's making the report. What does it say here? Such information shall not include specific actual information on a consumer's credit record obtained, it says it right here, obtained directly from a creditor of the consumer or from a consumer reporting agency when such information was obtained directly from the creditor of the consumer or from the consumer. It's telling you right there what they cannot do. But we see them do this all the time. When you submit a dispute letter, it comes back as verified. Oh, well, how did you verify this information? How did you verify this information is what we should be asking. And when it comes back verified, a lot of us feel defeated and saying, well, I'm never going to get this, I'll never get this item off of my credit report. How am I supposed to get this item off of my credit report if it keeps coming back as verified? Right? And that's one of the issues that we struggle with, because we don't know what the next step is supposed to be in the process when we have an item that comes back verified where the CRAs are not adhering to their responsibility under the FCRA. All right. The term CRA means any person who, for monetary fees, dues, or on a cooperative nonprofit basis, regularly engages in whole or part in the practice of assembling or evaluating a consumer credit information or other information on consumers for the purpose of furnishing consumer reports to third parties. Right? Which uses any means or facility of interstate commerce for the purpose of preparing consumer reports. So what is interstate commerce? Interstate commerce is any means of communication: email, telephone, fax, post office, postal mail. Interstate commerce is basically any means of communication. All right, so this is what I basically wanted to go over today. I'm not going to go deep into this today because it's a lot of information to digest just in this one section. And this is just the definitions and rules of construction of the Fair Credit Reporting Act, which is 15 USC 1681. So the reason why I'm starting this, these days of studying these definitions, is because I want us to be able to have the knowledge that we need to be able to properly assert ourselves and sort of do the work on our own, without having to go out and to hire someone to work on our credit for us, because it's not just about the credit. It's the fact that we are constantly being violated by these companies who are not adhering to federal law. So anytime that you're speaking with a company and you're trying to hold them accountable, or you're sending letters back and forth to a company trying to hold them accountable for what they're not doing pursuant to federal law, and they want to tell you about their company procedures and this is the way that they're supposed to do things, keep in mind that company policy does not trump federal law, right? It never did and it never will, period, point blank. These companies, credit reporting agencies, have assumed a vital role in reporting this information, so they are bound by the rules and procedures of the Fair Credit Reporting Act, right? So just keep these definitions in mind: the definition of a person, the definition of a consumer, and some of the things that are not supposed to be on your credit report. They're not supposed to be there. And so when you go and apply for a loan and you're approved and you go to sign the paperwork, companies are supposed to give you the option to opt out from credit reporting, and they never do 99.9% of the time. They don't properly inform you of your rights, nor do they tell you that you have the option to opt out from credit reporting prior to the end of the initial 30-day period of that item. And they're supposed to tell you this before this item is reported. They're supposed to provide you with clear and conspicuous documentation that gives you a clear overview of what your rights are in terms of credit reporting. But they never, ever, 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 ever do that. And I'll show you one more thing, and then I'm going to hop off. They never, ever, ever, ever do it. So we're going to look at one of the other privacy laws that a lot of people may know about, which is the Gramm-Leach-Bailey Act. This law right here basically speaks about the protection of non-public personal information. And this is 15 U.S.C. 6801. Okay, so if you look at 15 U.S.C. 15 U.S.C. 6801 is protection of non-public personal information. It is a policy of Congress that each financial institution has an affirmative and continuing obligation to respect the privacy of its customers and to protect the security and confidentiality of those customers, non-public personal information. Right? And that's what this section is for. Now, obligations with respect to the disclosures of personal information. Okay, what does it say here? Except as otherwise provided in the subchapter, a financial institution may not directly or through any affiliate disclose to a non-affiliated third party any non-public personal information, unless such financial institution provides or has provided to the consumer a notice that complies. So what does that say? They're supposed to provide you with a notice that is clear and conspicuous, that gives you the ability to opt out from credit reporting or the sharing of any non-public personal information. So what does it say? In general, a financial institution may not disclose non-public personal information to a non-affiliated third party. All right. So again, we're talking about that Bank of America loan that got charged off. Next thing you know, they referred it to a collection agency to collect on the difference of the charge off. The collection agency is considered a non-affiliated third party. An affiliated third party would be Visa card, right? It's an affiliated third party that provides financial products, same as Bank of America. A non-affiliated third party is a third party collection agency, right? So a financial institution may not disclose non-public personal information to a non-affiliated third party unless such financial institution clearly and conspicuously discloses to the consumer in writing or electronic form or other form permitted by the regulations prescribed that such information may be disclosed to such third party. Now, this semicolon here means and. When you're reading legal language, that semicolon means and. So not only do they have to abide by letter A, they have to also abide by letter B and letter C simultaneously, all at the same time. It doesn't mean one or the other, it means all of it. So what does it say? They have to clearly and conspicuously disclose. They have to give you, the consumer, the opportunity before the time that such information is initially disclosed. And they have to give you an explanation of how you can exercise your non-disclosure option. They have to tell you how you can exercise your non-disclosure option. So anybody that's currently watching the live, or if you come back and watch the replay, I want you to tell me how many times you went into the bank or you went into the dealership or you went in to apply for anything at all, and they say, hey, Ms. Bush, we just wanted to let you know that you have the option to opt out from credit reporting. Here are your forms, so you can go ahead and look those over and just let us know what you want to do. Never. When does that ever happen? Please, if this has ever happened to anyone, I want you to put it in the chat for this video that you have had this happen to you, where they gave you the option to opt out before that item is reported on your credit report, they actually gave you the option and notified you of your rights that item was not supposed to be, or that you have the option to not have the item reported on your credit report. Right? So this is the exception. This subsection shall not prevent a financial institution from providing non-public personal information to a non-affiliated third party to perform services or functions on behalf of the financial institution, including marketing. So a lot of the times when we receive these disclosures from these financial institutions, the one main thing that they always speak about is marketing. Oh, your information may be shared with third parties for the purpose of marketing, blah, 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 right? Marketing of the financial institution's own product or services. It doesn't say anything in this section right here about a collection agency. A collection agency is not an affiliate third party. They're a non-affiliated third party. The term non-affiliated third party means any entity that is not an affiliate of or related by common ownership. Common ownership. What collection agency you know is owned by Bank of America? They have a collections department, but a lot of the times they refer it out to a non-affiliated third party. They sell your personal protected information to a non-affiliated third party. If that is not the definition of violation of privacy, then I don't know what is. All right. So just to give you all a little bit of context as to how much we are literally being violated every single day of our life. And then we try to go after these companies, they try to make it seem like they don't know what you're talking about, right? And that they are doing everything that they're supposed to do in accordance with the law, but they are not doing what they're supposed to do in accordance with the law. All right. So I'm going to stop right there. It's 7:30. And so today we covered the definitions and rules of construction of the Fair Credit Reporting Act. Fair Credit Reporting Act, which is 15 USC 1681. You can look up that code. You can go to Law Cornell. If you Google 15 USC 1681, it's automatically going to take you to Law Cornell, and everything is pretty much laid out for you, right? All right, so we're going to go ahead and end it there. And tomorrow we are going to pick up at 15 USC 1681, identity theft prevention fraud alerts, which is going to be really, really good. So, all right, I hope that this was helpful and that it provided a little bit of clarity in terms of how the FCRA works and how we are constantly being violated as consumers. I will see you all tomorrow evening at 7 p.m. Have a good evening. Peace and blessings.